Here we go. Hello, everyone. Thank you so much for joining us. I'm just going to give people just a couple more minutes to log in here and get out from the waiting room. Okay, it's 6:02. I'm sure people will be coming in very slowly, but I do want to get us started because I know our panelist has a lot to go over, and we're anticipating that you guys will have a bunch of questions, which we will welcome. My name is Antisisa Green. Welcome to the Metropolitan Black Bar Association panel on how to write a law school exam. I'm so happy to have you guys here today. We are so proud that you joined us. I just wanted to open up and first I'll introduce Denise and she will introduce uh, our panelist for tonight. But I do want to say if you guys are not members of the Metropolitan Black Bar Association, I encourage you to join. Membership is free for all of our law students. And as a member, it will ensure that you guys will get information about all of the programs and events that our law student division is planning. And we have a lot of things coming up. This is just the beginning of what we anticipate will be an absolutely amazing what we anticipate will be an amazing program coming up. So I'm very quickly, first thing, I just want, can you guys just raise your hands if you're okay hearing me? Because I need a new computer, but my husband won't buy me one. Okay. Okay. So first thing I want to do, I'm actually going to launch a poll. Um, and hopefully you guys are having a better time hearing me. I'm going to launch a poll so we can just get a little bit of information about you. And then from there, I'm going to pass it on to Denise. Denise Mira is the co-chair of our pre-law and law student division for the Metropolitan Black Bar Association. She is also the coordinator for the MBBA's Law Student Liaison Program. If you have not heard of the Liaison Program, it is a brand new initiative that we have launched to make sure that we get input from everyone of our law student members. It's imperative for us to understand what you need, what you're missing, what you want, so that we can provide you with that information. I'm going to keep the poll open for just a little bit longer, but I am going to hand it over to Denise so she can get the poll results and also introduce you to our panelists. Thank you again, everyone, for coming.
Hi, good evening, everyone. I hope everybody can hear me. I want to make sure the sound is good. So if you could just quickly raise your hand and let me know that you can hear me. Can you hear me? If you can just raise your hand. Perfect. All right. Thank you so much, everyone, for the responses. I know that in the universe of Zoom, it's not the same effect. I promise that I'm amazing in person, but I'll do the best to deliver virtually. So as Anta mentioned, I am the co-chair of the pre-law and law student division for the Metropolitan Black Bar Association. If you have not been to one of my events, you have been missing out. I've already done 2 or 3 of them in terms of getting to know law students, understanding your needs, and moving and operating in places and spaces to make you win. That's my goal. My goal is to develop you and make you feel comfortable, empower you, and give you the tools that you need for your particular success. So in thinking about what this division is looking to do, we were looking to create programming. We wanted to create programming that we think you guys would need, which is the reason why we created this program, because we understand, one, that writing for a law school exam is very different, and there are many different things to consider, and many of us don't necessarily have the resources to go the extra mile and maybe get a tutor or something, right? So the point of this program is to give you a very high level overview of things for you to consider and give you tips and tricks and strategies to win. Now, the person that is giving this particular seminar today is somebody who's very near and dear and is very much a part of my success story. Ryan Nasim is a proud Toro alum, because I am from Toro, and he also works for the law department. Now, Ryan was someone in my law school career who helped me succeed. He gave me an opportunity to offer me not only his friendship, but advice and intel. So when I thought of this program, I thought of him immediately because he is a gem and I want to share him with our community to, again, make sure you guys win. So when you think about Ryan, this opportunity that you guys have today is to give you, again, the tools for you to win. And this part of the actual presentation itself will be recorded, but the Q&A is exclusive to the folks that are here on the actual seminar for you to ask real-time questions. And Ryan not only serves in this capacity to help mentor students, he also is a bar tutor. So Ryan is somebody who's here for you today and he's here for you tomorrow. So definitely keep his name, keep his contact information in your back pocket so that you guys have the opportunity to reach out and communicate to him whatever you may need. And in terms of me, my personal mission and my commitment to this division is to make sure that you guys are in a position to win. My contact information is available through the MBBA website. You can also find me on social media. I have received many different emails in terms of asking for programming and things, and I would love your input as well, because you guys show up and you guys are definitely doing it up by being here today. Thank you so much for your time. And with that, I'll hand it over to Ryan.
Good evening, everyone. I'll do the same thing that everyone else did before me. Can everyone hear me? If you can, raise your hand. Great. That was quick. Awesome. So first, before we begin, I just want to thank the Metropolitan Black Bar Association as well as Denise for thinking of me for this program. I really appreciate it and all the kind words that you have to say, Denise, every single time. So I'm trying to close this poll. How do I close the poll? Oh, there we go. All right. So based off of the poll results, it seems like most of you are 1Ls and most of you attend law school in New York City or the New York region. So I think that this program will be beneficial for you, regardless if you're a 1L, 2L, 3L, or a recent grad and you have to take the bar exam. So before I begin with the program, I just wanted to tell you a little bit about me and why I'm sitting in front of you and what my credentials are, because you're probably sitting there wondering, well, why Ryan? So during law school, I did perform really well academically. I graduated #4 in my class. I was on law review. And during law school, I was a TA for multiple different subjects, all of the doctrinal courses ranging from contracts, civil procedure, evidence, crim. And since law school, I have continued to tutor law school students, both for law school and now for the bar exam. My focus is mainly on writing the essays and how to write a law school essay and a bar exam essay within a timely fashion that addresses everything, that's coherent, and that analyzes the legal issues appropriately. So why is this program important for you? I think it's important because we're going to try tonight to demystify the law school exam. Coming out of college, if most of you are straight out of college going into law school, You probably have not seen what a law school exam or essay hypothetical looks like, and you probably won't know how to approach it on your first exam. No one teaches you this in college, and your professors in law school will likely not teach you this. While you're in school and in class, your professors are focusing on the cases that you have to read or the assignments that you're given, but they won't sit you down and say, this is the hypothetical you will be presented with. They may hint to it, but they won't tell you the whole hypothetical, and they won't tell you how to answer it. So unless you're given that information from someone or taught how to do it beforehand, it's kind of a mystery. And that segues into, how does law school differ from college? Well, we all know that law school, you're graded on a curve, and some colleges are also graded on a curve. But the biggest difference in the law school exam compared to college is you're not going to be tested on what you know. Everyone's going to go in knowing the same amount of law. You all learned everything. But the professor doesn't want you to regurgitate the information, which is mostly what you did in college on a final exam. You would spit out everything, vomit everything that you learned throughout the semester. What the law school exam is trying to do is it's trying to determine and analyze how you use the information that you learned and the material that you learned to a particular fact pattern or hypothetical. The law school exam, like the bar exam, will test on multiple things. It'll test your ability to identify legal problems in complex fact patterns. It'll identify applicable rules of law and what rules govern those problems. It'll ask for you to address the viability of particular claims or legal issues. And it's also going to test your ability to work under intense time pressures, how to write clearly, concisely, and organize your answer in a coherent manner that also prioritizes the legal issues that you're being presented with. And why should we learn this? Well, not only do we all want to do well in law school, I think as 1Ls and even 2Ls, that's your goal, is to do well in law school, but writing is a craft, but more so legal writing is a craft. And whether after law school, you're going to be a transactional attorney or a litigation attorney or clerk for a judge or something else, you'll be required to engage in some sort of legal writing. And it'll be required for you throughout your entire career, and of course on the bar exam. So in preparation for the seminar, I think I tried my best to give you guys what I know, what worked for others, what worked for myself, what worked for the students that I do tutor. And I also went above and beyond, and I spoke to some professors at different law schools to ask them, what are some tips? What are some do's and don'ts for a law school exam? What are you looking for, professor? And I got multiple responses, but pretty much all of the professors kind of want to see the same thing. So the goal for tonight is that you take away some tips and tools as a starting point as you begin to prepare for your final exams. I hope to demystify the law school exam and hope that you walk in on that day of the final exam being a little calmer and a little more prepared for what's about to come. Finally, for questions, obviously I would ask that the questions be, at the end of the seminar, but due to the rules and the code of ethics that you all posted, I don't think I can answer questions that relate to any particular hypothetical if they may be from a memo or a law school assignment that you're currently working on, but questions generally related to an exam or how to address a certain fact pattern or how to write it, we can address. So without further ado, I'll start the program. Okay, so preparation for your law school exam. I tell this to all of the students. Preparation should begin at the first day of the semester. And the way you want to prepare for your law school exams, your career, is by preparing for class. You want to prepare for every single class. And by doing so, what I mean is read all of your cases, especially if you're 1Ls. We're not used to reading these old, archaic, mundane cases that we're being presented with as 1Ls. So it's very important that instead of kind of cheating and jumping to a commercial outline before you read the case, you should read the case. Do the work to decipher out from that case, what's the relevant rule of law? What's the relevant legal issue here? What facts were important to the court when they were deciding a certain opinion? And I always tell students to read the footnotes that follow after the case in your case books. The reason why I say that is because a lot of law professors get some hypotheticals from those footnotes. They get some multiple choice questions from those footnotes. So if you read the footnotes, you don't have to memorize what's in them, but you can take note. And hopefully it'll be something that later on, as you're studying or if you're taking a final, you'll recognize as a problem. The other thing I would tell students is to write your own case briefs. I think that this is very important. If you do use a commercial outline, which I would encourage you to do, but I would encourage you to do it after the fact. What I would recommend is that you read the case through and through, no matter how long it takes you. You're 1L, so you're developing a skill set here. So you have to read that case and be able to filter out the information that's going to be relevant. Write it out yourself, because as you're writing it out, you may not know it now, but you're studying it again. You have just read the case. Now you're writing a case brief, and then you're going to talk about it in class. So it's repetition. You're doing it more than once. And in addition to that, you're also preparing and practicing IRAC, because our case briefs are essentially IRAC. I would also say to talk it out. Everyone's different. And that was my biggest disclaimer. I forgot to mention that. The one takeaway you should take from this course is that everyone is different. We're all different. We're all different students, and we study different. We have different study habits and work ethics. So what works for you may not work for everyone else. And everything that I mentioned here may or may not work for you. So take from this what will work for you and apply that. So if you're one of those people who works better in a study group environment, or if you work alone, I would say talk out the issues, talk out the case, because when you hear yourself talk about it, it may highlight to you what an issue is in the case, or what the problem was before the court and how the court addressed it. If you talk it out amongst others within your study group or your friends, or that one person you study with, or even yourself, you may be able to get differences in opinions on what other people believe are the important facts, or what other people saw was the issue. The other thing I would say is try to ask yourself questions as you're reading your cases in class. Why is this case in the casebook? What am I supposed to take away from this? Why does this case differ from the case before? Is it adding an exception to the rule? Is it abolishing that prior rule? Are we creating a new rule? What is the purpose that this case is in the casebook? What am I supposed to take away? Because that's going to be the biggest factor that the professor might focus on in class. I would also say take notes during class. Some people are visual learners or audio learners. I was a person that I needed to take notes. I find that when I write things out, it sticks in better into my brain. And I think that works for a lot of people. So I would encourage you to, if you don't take notes, be engaged and be active during class, because the more you pay attention and the more you're focused during class, it's going to work out to your benefit in the long run. So just a little more on writing your case briefs. Remember that writing your case briefs is practice. So as you're doing this as a 1L, you're practicing your IRAC, and that's something that is going to follow you all the way through the bar exam. So don't try to shortcut it and use a commercial outline. I mean, use the commercial outline to supplement things. Use the commercial outline to maybe help you understand things that you may not have understood while reading the case. If you didn't get the rule of law, or if you didn't get the issue right, you can use the commercial outline for those purposes. But the case briefs are for you. So you should keep it brief, but you should also know why you're using it and what you're going to use it for, and know your professor. What is your professor going to ask? What types of questions? Do they want to know about the procedural history or do they not? So just remember that the case briefs are for you. And the reason why I say create your own outlines is your own case briefs is because as you get closer and closer to the end of the semester and you're studying for finals or midterms or what have you, the case briefs will be a helpful tool for your outlines and for your law school exams, because in each brief will lie a rule of law. And if that rule of law is missing from your outline, you'll be able to refer back to your case briefs and say, oh, I missed that rule. I need to add that to my outline. Or I don't even remember what this case was about. Let me go back and read it. So now we're going to get into outlining. During law school, I made my own outlines, and I encouraged all of the students that I TA'd and all of the students that I tutor now to do the same thing. I'm sure you all know as 1Ls and 2Ls that it's very easy to get your hands on that A+ outline or the Cali outline or the best outline you could find. And that's great, but that outline worked for that person who created it. And I think that by creating your own outline, you're studying again. So I would encourage you to create your own outlines. And the way you should do so is outline every week. If you haven't started outlining, I think now would be a great time to start as we're getting closer and closer to finals. But I would recommend that you outline at the end of every week of class. You can add to your outline your notes from class, what the takeaways were, or the rules from your briefs. You can add to your outline, and you'll realize that as you get closer to the end of finals, your outline probably just needs some tweaking, or it's ready to go and you can start studying, or you can start outlining your outline. And what I mean by outlining your outline is sometimes it's not beneficial if you have a 50-page outline. Sometimes it's more beneficial if you condense your outline even further. Some of the most successful people academically in law school are the people with the shortest outline. And it's not because they know the law better, but it's because they know what they know and they know what they don't know. And that's something that you want to try to focus on as you're studying and outlining. That's something that you want to pay attention to. You also want to keep in mind what type of exam you're going to be taking for your class, whether your exam is open book or closed book. I would say regardless, if your exam is an open book exam, you should prepare for a closed book exam, because the chances are that you're not going to have enough time to go through your outline during that open book exam. But if you do have an open book exam, what I would recommend is, and this is what I did my first year, I think, I had 2 outlines, one that was about like 15 or 20 pages, and the other outline was 1 page. And that 1-page outline, I called an attack outline, and other people will call it that too. It's an attack outline. It will lay out all of the topics of that for that course during that semester that you covered. And you'll use that to be able to spot the issues if you're having issues, if you're having problems spotting issues. So just be prepared that if you do have an open book exam, your 20 or 30-page outline may not cut it. You're not going to have time to flip through all of those pages. So you should always prepare for a closed book exam. You also can use your outline in your study group, and if you do have a study group. And I think it's really beneficial because once you begin talking out issues with other people, you will understand or begin to realize, wow, I really don't understand this topic that much. I need to go back, or I need to add what she just said into my outline. Or you'll understand, oh, wow, I really know Battle of Forms really well, UCC 2207. I don't need to study this at all. I can condense it or shorten it or eliminate it from my outline and use that space for something that I don't quite understand that much. So the outline is obviously it's for you. It's not for anyone else. So you should use it for yourself and tailor it for yourself. Now, getting back to getting outlines from other people, it's very helpful because as a 1L, I don't think I knew what I was doing when I started outlining. I just started writing something. So it's good for a point of reference. It's good for a template on how to start. And it's also good to make sure that you have everything that was covered in class in that outline. You can use it to kind of compare if you're missing anything or if there's anything that you needed to add. But I wouldn't rely on someone else's outline too much because there may be things that are missing in their outline because that person understood that topic very well, so they didn't include it in their outline, and that may not be true for you. So that's why I encourage everyone to create your own outline. And again, this goes back to repetition. You're adding to what you already did in class. So now you have already read your cases on your own. You've briefed your own case briefs. You've participated in class and you've created your own outline. And now you're reading your own outline coupled with reading the commercial briefs and reading someone else's outline. It's repetition. It's happening over and over and over again. And you may not feel like you're studying, but your brain is taking in all of this information. So it can only benefit you in the long run. Okay. So preparing for the exam. I would say that as we're getting closer to final exam period, if you have not looked at a prior law school exam, you should do so as soon as possible. I know that most law schools have their professors' past exams published, usually in their library, and you can gain access to those past exams. You should start doing that. You don't necessarily right now need to start drafting an answer, although it can't help you if you, it can't hurt you if you do. But you should start at least looking at those past exams to become familiar with the format of not only a law school exam, but your professor's law school exam. Because sometimes you'll be able to see a pattern. This professor likes to test on negligence per se a lot, or this professor always has a offer issue followed up with promissory estoppel. So it can only help you if you start looking at past exams. And if you have the time, I would encourage you to start drafting answers to those past exams. You can do maybe one or two under normal conditions, non-exam conditions, just to see, did I spot the issues and was I able to write an answer? But then as you begin to practice more, you should take them under exam conditions. While you're studying for your final exams, this is the one thing I tell everyone. Try to focus on understanding the material. It's a lot of material that you're going to be tested on. You have more than one final for more than one class, obviously. And you may feel the need to memorize because that's what most of us did in college. But if you focus on understanding the material, if you focus on understanding the legal concepts and how they all connect with each other, how we get from offer to damages, then you will find that the studying period will be easier for you because you'll be able to recognize issues by just using the facts alone. And obviously speak to upperclassmen. But be selective in who you speak with. You don't want to just speak to, the person who got a C on the last exam who's going to say, oh, just use my outline and just walk in there and write this and write that and you'll be fine. Try to be selective in who you speak with. Speak with those who are TAs. Go to TA sessions. If your school offers TA sessions, I would highly recommend that you go. I went to every single TA session and I know that Denise did as well. They're very helpful because from each study session or TA session or each time you speak to an upperclassman, you gain a little gem or just a little bit of more knowledge that you didn't have before. Even if you walk away with one thing that you didn't know, it's beneficial for the exam. I would also encourage you to meet with your professors one-on-one. During class, your professor may or may not express what they are expecting to see on their exam. Some professors will say, yes, I want to see IRAC. Some professors will say, I don't want IRAC at all. I just want you to address the issue and analyze it. And you're confused. What does that mean? Some professors may say, I want to see CRAC or I want to see CREAC. So meet with your professor to understand what they're looking for on their exam, what their style is. And you can even try to push the limit a little bit. And if you draft an answer to a past exam, you could walk in there with your printed answer into your, or virtually walk in there or email it to your professor and say, do you mind looking at this? Am I on the right page? Is this something that you would be looking for? Or is this sufficient? I mean, the worst that can happen is they would say no, but knowing what your professor is looking for, I think, is really key. Also, you should look at sample answers if they are available. Some schools do publish the top answers to certain law school exams. So if your school is one of those schools that have sample answers available, you should look at them because then you know what your professor is looking for and you know the format that you need to write for the bar exam. So I have here on the slide closed book exam and open book exams, and we just spoke about this. But what I really mean is walk in there with a game plan. When you're walking into your exam, if you know that it's an open book exam and you don't have any notes with you, and maybe it's a class that you struggled with a little bit, or there's multiple topics that you know you're going to forget, as soon as the exam begins, a good practice is to start writing down either on your scrap paper or on your exam essay, and then you could delete it after if you're taking it online, the topics that you may forget. You can just do a quick outline of everything you may forget or everything that you covered in class, just so when you're done with the exam, you can go back and say, okay, I covered intentional torts, I covered negligence, I covered products liability, and then you can move on from there. And this may all seem very obvious to you guys, but I have to say it anyways because I think it's relevant to our program tonight. The night before the exam, don't pull an all-nighter. I wouldn't recommend it at all. The next day, I did that with my first final exam, and I was groggy, and I did not think clearly, and I was just a grumpy person. So get a good night's sleep before the exam so that when you wake up in the morning, you're refreshed, you are a little bit more clear-minded, and you can be as calm as possible, and also eat a good breakfast. I'm a firm believer in if you feel good, you will do good. I even carry that through my practice today. If you feel good about yourself physically, you will more than likely perform well on the exam. You'll have the brain capacity to do so. Also, remember, and this goes back to not pulling an all-nighter, you don't know what you know. And what I mean by that is you're going to realize that you know more than you think you do. When it comes down to, and you realize that while you're taking the final exam, because issues start to pop out at you and you're like, wow, I didn't even realize that I knew this so well. And you're just typing away and you're writing your answer. If you've done all the work and all of the preparation that we just went over, that includes all of that repetition, you're going to be more than well prepared for the final exam, and you're going to know more than you think you don't. So now we're going to get into actually tackling the law school exam and writing the essay. A good practice that I would say is to read the call of the question first. If you're in bar exam world, that's very important because you don't know what topics are going to be tested. So by reading the call of the question first, it can focus you to, okay, this is a First Amendment or constitutional law essay. But if you're in law school, you know that if you're walking into your criminal law final, that you're going to be tested on criminal law. But You may not know what the specific issues are that you're going to be tested on. So I would say read the call of the question first, because the call of the question may signal to you, okay, the professor is looking for an analysis on felony murder, or the professor is looking for an analysis on a defense to felony murder. And that way you can look for those issues as you're reading your hypothetical. I would then say read the essay very carefully. Like I said, every professor is different. So some professors may have a bar exam-like essay where they'll probably give you more than one essays that are a page long and maybe 3 or 4 issues or questions that relate to that essay and ask you to answer. Other professors are different. Some professors will have one essay that's about 7 to 9 pages long. 7 to 9 pages full of facts, complex facts, filled and riddled with many different issues. And it will be your job to decipher and spot those legal issues and know which rules apply. Sometimes the professor may not have a question in typically one of those long fact patterns, and they may just say, discuss the claims. And in those circumstances, I think and in all circumstances really, when you're reading the exam, these are the things you want to start doing. It's going to be active reading. So as you're reading the exam, I would carry a pen or a pencil with me and maybe a highlighter, but sometimes you don't have time to highlight. But it's really important to circle parties, the names of individuals, because more than likely, one person is going to be suing another person, or the names of companies, because more than likely a company may be a defendant, or a company may be suing another company. You also want to take into consideration locations as they may appear in your fact pattern. For civil procedure, locations matter for purposes of jurisdiction. Where a person is domiciled would matter for diversity jurisdiction. For purposes of tort, locations may matter for the purposes of duties that are owed to tenants. Was that person in another person's property? Were they trespassing? So circle parties, circle locations, circle injuries. And we all know why injuries matter, because it relates to damages. And it's the causation factor that appears in almost every area of the law. You want to circle also or highlight the actions or intentions or spoken words of individuals in the fact pattern, because those are the key facts that you're going to use in analyzing these claims in your law school essay. The spoken words matter. They will give you triggers to a person's intention. Did he or she intend to be bound by this offer, intend to be bound to a contract? Or did he or she intend to commit a harmful or offensive bodily injury? So keep in mind all of those things as you're reading actively through your hypothetical. You want to read carefully, but not slowly. And you also don't want to read too fast. You want to read at a decent pace. As you're taking the exam and as you're doing that, one of the other things I would recommend is try to not get distracted as much as you can. I don't know if most of you are in school in person or if you're doing this virtually, but try to not get distracted by other individuals or anything that may happen around you. One thing that I would recommend to a lot of people is just pop in earbuds, the little foamy ones that you roll up and then they expand in your ears. It's a good way to help you focus on what's exactly is in front of you and kind of drown out all the noise and everything around you. Once you're done reading the hypothetical, it's really good to prioritize issues. So let's take torts, for example. If you're reading a torts essay, maybe negligence might jump out at you as like the big issue. But recognize that if that's jumping out at you as a big issue, chances are everyone's going to get that issue. Everyone's going to analyze that issue. And there are probably other little mini issues that are hidden within the fact pattern. So maybe the negligence answer may be something that you would like to address first, and then move on to all of the smaller issues. Or maybe the smaller issues matter to the claim more, and you should address that first and then get to your negligence issue. Because chances are, the reason why I say prioritize issue is because professors always say that the main issue is not worth much points. Sometimes it is, sometimes it's not. If it requires a detailed analysis, then it probably is worth more than we think. But if it's pretty obvious and it's very quick and short and concise, chances are it's not worth that many points. Like I said, it's all professor specific. So by reading the fact pattern and had you done the appropriate studying, you should be able to decipher which issues take more priority over the other. Organization matters. And at the end of the segment, I'm sure all of you are going to write organized essay for your law school exams, because if you implement the IRAC formula or the CREAC formula or some sort of formula like that, then your exam would be organized. But apart from IRAC, the other thing that you would like to make sure that you're doing in organization is organizing your claims and your parties and your answer. So if you have a multiple question essay that is focused on different types of legal issues, it will be helpful for your reader, who is your professor, to show that you've organized your answer in a way that they can follow it clearly. So if you have let's say in contracts, let's say you have an offer issue, you can title it question 1, offer, and then analyze your offer issue. And then the second one can be question 2, promissory estoppel, and then analyze that issue. And it will just, it's more helpful for the reader, and it's easier to get through your exam. If you're taking torts, for example, and let's say you have one party who gets so injured by multiple different parties that they end up bringing claims against 5 or 6 different individuals, entities and personal individuals, it would be helpful to say Jack versus John, and then you analyze that claim. Jack versus construction company, and then you analyze that claim. So that's what I mean by organization. Don't get too hung up on minor typos if you're typing your exam, or minor grammatical errors. The professor's not looking for that. Most professors are not looking for that. Granted, the better answers will be those that lack typos and are grammatically correct, but your key here is to kind of get through the exam in a timely fashion and address all of the issues that you can and move on. The other thing I want to say is, if your professor is someone who's going to give you multiple essays within your final exam, the minute you open that exam, I would highly recommend that you just start with the first question. Do not flip through the exam saying, okay, I don't like this essay, or I don't like that essay, or okay, essay number 3, I'm going to do that one because I like this one the best. You have to finish the whole exam. If you start picking, and this is for the bar too, if you start picking, you're wasting time, because someone like me or someone else in the class, I'm already starting to type my answer for the first exam. So remember, you're graded on a curve, you're graded against each other. So at the end of the day, it is a competitive environment in that sense. So you should just start with the first question, regardless if it's not your strongest area or something that you remember or recall that much from your studying. But had you done all of the work before, you should be able to answer it at least to gain the most amount of points possible. Okay, so now we're going to get into the IRAC essay writing. So if you're someone, I know we have a lot of viewers today, but if you're someone who this is your first time learning about IRAC, I'll explain to you what it is. If you've heard about this so many times, I apologize, but I don't think it will hurt repeating. IRAC just stands for Issue Rule Application. And I always add an analysis. Sometimes I put 2 A's. So Issue Rule, Application, Analysis, and Conclusion. The way you get better at IRAC is by practicing over and over and over again. you'll realize that the more you practice writing out exams in an IRAC formula, you will get quicker at it. And you'll add things to it, or you developed an advanced way of doing it in a quicker format than when you were a 1L as opposed to a 3L. IRAC will also keep you organized, and it'll help you answer the question. It'll help you with your professor while they're grading the exam. As you're reading and this should have been in the prior slide, my apologies, but as you're reading the hypothetical, I want you to ask yourself why each sentence matters, and does it matter, and should it matter? If your professor is one who has a very long fact pattern, one essay, chances are a lot of the facts in there are not going to be legally relevant to the answer. But if you have a short exam essay, hypothetical, then chances are every sentence may matter for some reason. It may relate to an element of the law. It may relate to an exception to the rule. It may relate to a minority rule. And if you question why the sentence is important, it may highlight, or light bulb may go off like, okay, I remember this. This is what this relates to, and this is why this is there. If you're having trouble issue spotting, or you don't even know what that means, I've tried to break it down into very basic examples for you. Your professors on your law school exams are not going to say in the hypothetical that a cat was in the room. They're going to say something like, Ryan was in the room and heard something that meowed, that liked to eat tuna, and saw it chasing mice. It's going to be up to you, the law student, to say, well, the first issue is whether or not this is a cat. And the same thing for my elephant example. So facts in your hypothetical are going to be presented to you that jump out, or maybe they don't. But the facts are there to present a legal issue and to address the rules of law. If you're in tort world and there's a bunch of elements to a rule, each fact is going to relate to whether or not that element of battery has been met, or that element of negligence has been met. And you want to use the facts to kind of help you get there. All right, so as you're crafting your exam essay answer, time is running. Okay, so as you're crafting your essay, the issue statement you don't get a lot of points for. So the issue statement, you want to be in and out, quick. So the issue statement should insert the legal issue and the facts that created that legal issue. And you can just be concise and say the issue is whether John committed a battery when he threw a pie in Jill's face. You don't need to be wordy. Try not to be wordy. Not the first issue that we will be addressing that is up for consideration is just the first issue is whether blank when blank. The rule. In your rule paragraph, be sure to not include facts. This was stressed from every law school professor that I spoke with. Do not analyze the facts. Do not include any facts in your rule paragraph. Your rule paragraph is exactly what it's supposed to be. It's only law. And you can highlight to your professor that you're in your rule paragraph world by using words like under New York law, or under common law, or it is well settled that, or pursuant to the majority approach, or courts have held. And this is something that I tell a lot of people who are going to take the bar exam, because I got this advice as well. I've never had to use it, but I know other people who did, and it worked well for them, is if you blank out and you don't know the rule of law, use the facts to create the rule. So kind of make it up, but start off your rule paragraph by saying something like under common law, or it is well settled that, and just state whatever the rule of law should be. Chances are you may get some points for at least trying. The point is, don't leave anything blank on your exam. In your rule, you want to state any distinctions if they apply, state any exceptions if they apply. And it's really good to have a beefy rule paragraph, because you're going to use your rule paragraph to kind of guide your analysis and your application, which is obviously where you garner the most amount of points. You're going to go through each line of your rule or each element of your rule and use that while you're analyzing the claims. If you're in a constitutional world or a class where cases derived from constitutional cases, then the way your rule paragraph should be set up is you want to first address constitutional provisions, then statutory provisions if your school covers that, then case law or black letter law, and then finally, what's the public policy behind that law? Just throw that in there. It's probably a 1 point. It doesn't matter if you don't, but it can be helpful. You also want to define any legal terms of art. So if you say something like, a contract can be voided if deemed unconscionable, you have to define what unconscionable means. Some court has ruled what unconscionability means. So be on the lookout for that. Case law citations are really not that important, but, and you're not expected to remember every single case that you read throughout the semester. But what I would say is you should cite the cases that are the seminal cases, those landmark cases, like Paul's graph in torts for foreseeability, or international shoe in civil procedure. If you know that issue arises, just throw it in there. You don't have to have the correct citation, just the word and underline it, and you should be fine. So now we're going to get to the most important part, which is the application and analysis. So this is where you get majority of your points, and this is where it's going to separate every law student from each other, because some people will know what to do, some people will have some idea of what to do, and some people won't have any idea what they're doing at all. But for all of you here, I'm sure you're going to do fine because you're here in this course, so that means you're really committed and you're going to do well. So the point of the application and analysis is to apply the law to the facts. Like, you want to combine the two to come to a conclusion. And it requires reasoning. Some law professors are going to look for rule-based reasoning, which is basically you taking the rule of law and applying it to a set of facts to achieve some sort of result. Some will also look for analogical-based reasoning. Usually not required, but maybe some of the facts will be different or similar to a case that you read in class, but may have one fact that's a little bit different and that will tweak the outcome. And for that, you should address it in your application. And some professors will also look for, at the end, a policy-based reasoning. John's claim is going to fail because the legislature's intent in creating this rule was for this purpose, and his claim doesn't satisfy that purpose for this reason. So a lot of this has to do with knowing your professor, knowing what they're looking for, and giving them exactly what they're looking for. What you should not be doing in your application and analysis. This comes from law school professors. Do not regurgitate the law. So you shouldn't have what was already in your rule paragraph listed again in your application and analysis. You also should not just restate facts. You shouldn't say, John pulled the chair from underneath Jill, period. We know that. Why does it matter? You have to add in why it matters. Don't show everything that you know about the law in your application and analysis. Like I said before, that's for the rule paragraph. It's really important to stay organized here. Don't be conclusory. Don't just say, Barry will prevail on his claim for negligence, or Barry was negligent, or Barry had a duty. Why? You have to offer an explanation. And don't only argue one side. If you do, you'll probably still do well, but remember there's going to be someone in that room who's going to throw in the counter argument. And that leads me to what you should do. And you should argue both sides. In law school, I had a professor, my contracts professor, who told us he did not want IRAC. All he wanted was for us to analyze claims, analyze the issues. He didn't even want a rule statement. He didn't want an issue statement. He just wanted and conclusion, application and conclusion. And so what's a good thing to do in arguing both sides is pretty much when you're reading your fact pattern, you'll be able to tell which argument will prevail. But there may be a fact in there that will tweak it or throw it off a little bit. But if it doesn't change the outcome, then it's likely only worth one sentence. So after you finished your analysis, you can say, defendant will argue X, Y, Z, but that claim will fail because, and then you add the reason why. But if it's an issue where, I don't know what the outcome is, and this is not very clear, and this is very different from what we read in class, then chances are everyone is probably thinking the same thing in the class. And the professor purposely made it like that. And this is a chance for you to garner the most amount of points by arguing each side, because each side has a good argument to be made. So show your lawyerly skills and say, plaintiff will argue that there was an offer because X. D will argue that there was no offer because Y. P will prevail because X. And do that for each element and each issue. Like I said, the application and the analysis is the most beefiest part of your essay. So you want to show your work and explain why the outcome is warranted. The whole point of this is to weave the legally significant facts and the law together. So like I said before, if parties are identified as being citizens of a specific state, or if the facts are about domicile, then it's more than likely for Civ Pro, those of you who are taking it, that this is going to be relevant to a diversity jurisdiction issue. And you would want to highlight that. So like we did for our issue statement and our rule statement, our issue statement starts with the issue is blah, blah, blah. Our rule statement starts with under New York law, under common law, blah, blah, blah. We're going to signal to our professor again that, hey, we're starting our analysis. And the easiest way to do this, and most common, is just by saying here and comma and start your analysis, or in this case, and start your analysis. The words, if you're having problems with your analysis and your application of the law and the facts and weaving them together, you have to use connector words, which is something that I teach to everyone who's a law student and taking the bar exam, who feels like they don't know what to do when it comes to the analysis part. Connector words are words that are going to connect the applicable law to the facts. And that's the way you're going to weave the two together. And that's the way you're going to have the most beefiest and well-articulated analysis paragraph. And those words are words like because, when, by, since, as a result of, in light of. And I'll show you a specific example in the next slide. So as you're, I just need a drink of water. Give me 1 second. As you are writing and attacking your analysis for the exam, you want to use your rule paragraph and read the hypothetical and the facts in the hypothetical to write your analysis. And this is a little formula I came up with. It's going to be legal conclusion plus your connector word, which is those words we just mentioned, because, when, by, in light of, as a result of, and then the facts that support that conclusion. And you'll see an example of it here. It says here, Jack owed Jill a duty of care. That's a legal conclusion. Then we're going to have our connector word, because, and now the facts that support that conclusion. A tenant has a duty to guard against known and obvious dangers, period. Jack breached the duty of care when, connector word. Prior to that was the conclusion. Breach of a duty of care is a conclusion. And now the facts. He failed to state that he was walking with hot water in a common area, period. And you see I keep doing the same thing over and over again. Now you can make this even more beefier. This is a generic answer. This may be like a B answer or even a C answer. But what it's doing, and the purpose that it's here, is to show you how to connect the facts with the rules of law. You can go even further with the first sentence where it says here, Jack owed Jill a duty of care because a tenant has a duty to guard against known and obvious dangers, period. The next sentence could say, Jill was a tenant because, and use the facts to state why Jill was a tenant, because that may be a legal issue too. And then the next sentence could say, there was a known and obvious, or there was a known danger or a known and obvious danger because, and use the facts to state why there was a known and obvious danger. And then once you've analyzed that entire claim, address the counter argument. Address it. If it's an issue, if the counter argument relates to, let's say, a duty of care or a breach or maybe damages, then address it in that section as well. Another way that people approach it is the last point where it says, here, Jill will argue that Jack owed her a duty of care because blank. Jack will argue that he did not owe Jill a duty of care because blank. So it's doing the same thing, but it's doing it quicker and in a way that can kind of garner the most amount of points because you're arguing both sides simultaneously. A lot of professors tell me that one of the things, and this obviously relates to know your professor. So some professors will say like, the issue was very unclear. The issue's up for debate as to whether or not he or she was negligent. So in those instances, it may be acceptable to not be so forceful in your conclusion and say clearly, yes, Jack was negligent. In those instances, it may be better to say it is likely that a court may find or that a reasonable jury may find that Jack is liable to Jill for negligence. But some professors want you to be clear. If the issue that they presented to you, they determined was clear enough, then they would like for you to be a little clear in your conclusion. But like the issue, the conclusion is not worth that much. Everything comes out of the application and analysis section. So before you move on from your essay or you finish your exam, and while you're taking the exam, remember timing, right? You're under exam conditions. So if you find out what the exam is going to be like prior to the day of the exam, you'll know how much time to allocate to each section of the exam, should there be multiple sections. Remember, like I said before, everything matters in that fact pattern. And I threw in there California Civ Pro story because I wanted to just share with you a quick little story from my 1L year. I was running out of time. It was 1L Civ Pro, and the biggest issue was whether or not these two parties had jurisdiction to bring a claim in New York, in a New York court. But there was a little fact in there, one sentence that addressed California. And I knew that that was thrown in there for some reason, but I did not have enough time. I think there was about 3 minutes left on the clock. So if you are running out of time, but you know that there are issues that are left to be addressed and that you have not done already, throw out Iraq, throw a little heading. What I did was I just wrote California and just do the A, analyze it. And all I said was the parties may be able to bring a claim in California because, and use the facts to support it. There would be no issue of diversity jurisdiction because, use the facts to support it. That way, you can gain the most amount of points and still address those areas that you're running out of time that you did not have the time to address before. If you do have some time left, look at the fact pattern one more time, because chances are the second time you read it, the third time you read it, you're going to see facts that you did not see the first time around, because that's the purpose of a law school exam, is to hide little gems in there for you to pick up along the way. Make sure you've answered all of the questions. And what I want to say too is follow the directions. So if your professor says you are a first-year attorney at a law firm and your partner has asked you to create a memo addressing this issue, then write a memo, write to, from, regarding, follow the directions. Same thing for the bar exam. And if you need to edit and you have additional time, your answer, you can edit it. I rarely had time to do that, and I rarely know people who have that much time to do that. If you probably end your final exam with a lot of time left, you're probably missing out those little issues. So it'd be worth it, instead of focusing your time on editing, to reread the problem and see if you can spot any more issues. And after the exam, obviously relax. It takes practice. Remember that everyone has different levels of experiences. Some of us have been out of school for a while. Some of us have not. Some of us come from families where 5th or 6th generation lawyers. Some of us are 1st generation lawyers like I was. So grades will matter to some people who want to go to big law, but they won't matter for everyone. But so keep that in mind. Yes, they're very important in your 1L year and for your careers beyond, but you know, they don't matter for every single job. So I just want to leave off with that point because I think that's something to just throw out there. Employers look beyond grades as well. They look at clinicals and everything else that you do outside of that. And I think I covered most of this. These are just a word from your law professors, some of the law professors that I spoke with. I think one of the things that I didn't cover is longer is not necessarily better. Sometimes professors will give the highest score to the shortest answer because it's concise, it hit all of the relevant points, it analyzed the claims very properly and organized, and it covered everything in a timely fashion. So just remember that if you find that you're writing a lot, it may be because you don't quite understand the issue or you're unsure about the conclusion and you may just need to move on. Also, don't write in I's, or we will discuss, I would argue, I think. Answer the question objectively. And finally, I think, okay, 6 minutes over. Finally, just thank you to everyone. Some of the good sources that I used during law school, and I think you guys should all use, is if you go to the New York State Bar Exam website and you click on past exam essays, you will find past bar exam essays and the sample answers that go to that. So you can see what a good IRAC looks like or other formats that may work for you. Also, a lot of students use Professor Darrell Kleinhaus's book called Acing Contracts. Although it only focuses on contract law, it also talks about how to write a A+ law school exam. So thank you to everyone. I hope this was helpful and I hope you enjoyed it.
Thank you so much, everyone. And thank you so much for that, Ryan. Now we're going to move on to the Q&A portion of this. We're going to take a couple of questions. I'm going to go ahead. There was a question in the chat, and this